First, have you watched the Zurofsky versus Texas documentary?
I have not.
Can you tell me what your decision was, what your thoughts were with regard to your decision not to repeal the 1925 portion of the Vernon's Code?
Well, Senator, in 2021, the House and Senate passed legislation signed by the governor, which affirmed, the legislature found, a finding is the proper legal term, the legislature found that those pre-Roe statutes were still in existence. And Senator, you're a very sharp lawyer, but often we'll say a court struck down that statute. But of course, we realize that a court, even the highest court in the land, has no authority to strike something from a statute. All the court can do is issue an injunction saying this law cannot be enforced. All that to say, Roe versus Wade in 1973 enjoined enforcement of Texas pro-life laws, but they remained there, and Legislative Council will confirm to us that those statutes are still on the books, quote unquote, still in the code. And so once Roe versus Wade went away, those statutes were no longer enjoined. So sorry for the long answer, but you know what I'm talking about. In 2021, the legislature made a finding that those laws are still in effect, and we believe the Fifth Circuit is going to rule on that. But in this bill, in Senate Bill 31, the legislature having addressed that, we didn't step into that debate at all, if that's what you're talking about. I hope that answers your question.
I believe it does, in a way. You agree, it sounds like, that only the legislature can explicitly abrogate a section of code, that only this legislature can actually get rid of the 1925 portion of Vernon's Code, correct?
Senator, I believe that's right. There's a Fifth Circuit case from some years back which held, I'm not sure if it was in dicta or the holding, but this case indicated that those statutes had been repealed by implication. But with deep respect to the court, I believe that's wrongly decided, and I believe the Fifth Circuit will rule differently when it's before them.
So as the author of this bill, you have made the conscious choice not to use, not to repeal the 1925 portion of the Vernon's Code, correct?
Well, of course, that would take a vote of both houses and the governor's signature, but yes, you're correct. In this bill does not seek to repeal those pre-Roe statutes. That's definitely correct.
Although, under your committee substitute, this bill does explicitly say that irrespective of those old statutes, a pregnant woman will not be prosecuted. You have chosen to put that in the bill.
Clearly and unequivocally. That's right, Senator.
And I deeply appreciate that. Also, in Section 8, you have included a list of circumstances that shall not be considered aiding and abetting.
Yes, Senator.
And that list is a non-exclusive list or an exclusive list?
Senator, let me look at the specific language. The language is specific, and in its context, I believe it covers the type of speech, the type of conduct that's addressed. And so I'm curious to see how you read it, but the following activities do not constitute aiding or abetting under this subchapter. There's a specific list there, so that would be the list.
So you do not believe that there are any other circumstances that should be excluded from aiding and abetting?
Senator, the intent of this bill is to exclude only these listed.
So those specific circumstances listed in Section 8 and the explicit prohibition on prosecuting the pregnant person. Other than those, everyone else who is open to criminal or civil prosecution under any existing law is still vulnerable to civil or criminal prosecution under existing law.
Senator, that's correct. Whatever the law is today, before this bill passes, those situations you're describing are not affected by Senate Bill 31. Other legislation in this session could amend those codes further, but on this bill, I believe you're correct.
Now, also in section 9, page 4, lines 14 through 18, that section requires that the death of a fetus be accidental or unintentional. Do you believe that that section will increase C-sections to potentially save a probably doomed fetus?
Senator, I want to make sure I'm in the right place. Forgive me, we're on page 4. Is that?
I believe it's page 4, lines 14 through 18. This is in an exception to the application of each law described by subsection A. The death or injury of an unborn child resulted from treatment provided to a pregnant female based on a physician's reasonable medical judgment if the death of or injury to the unborn child was accidental or unintentional.
Well, Senator, that's abortion. Of course, is using means to intentionally take the life of the unborn child. And so that language restates that if there's not an intentional act of taking the life of the unborn child, then that would not be an abortion.
If a doctor is trying to save the life of a patient and they know that the procedures that they are deploying to save the life of the patient are also going to cause the death of the unborn child, is that accidental or unintentional?
Oh, Senator, forgive me, are we talking about a situation where, and if I'm wrong, you tell me, are we talking about that situation where a pregnant mother may be diagnosed with cancer and may need aggressive cancer treatments? And so the doctors, in some cases, will say, this cancer treatment that the mom needs, this could harm or kill the unborn child. I want to make sure, is that the situation we're referring to? I want to make sure I'm in, because that is addressed in the bill.
Yes, it is. Whether it's cancer or some other serious illness like renal failure, or some other circumstance that is clearly life-threatening.
Thank you, Senator. The language in the bill is to make sure that that is not, if a treatment is given to a mom and it is not given with the intent of taking the life of the unborn child, that's not an abortion. So if that's helpful, I think we're talking about the same thing.
And I deeply appreciate that. I just wanted to get the legislative intent on the record that even if the doctor knows that the treatment to save their patient's life will cause the death of the fetus, that is not considered intentional.
Because it's the life of the mother. You're exactly right. Yes, ma'am.
I wanted to make sure of that. And in that circumstance, does the patient have the right to explicitly choose treatment or an abortion if the situation qualifies as that kind of medical emergency? Or is that entirely the physician's decision?
Now, Senator, in that situation, of course, the patient would decide whether to receive the treatment for cancer to save the mom, and would decide whether to receive the treatment to save her life, which could harm the unborn child. That would obviously be the mom's decision. I don't think the bill speaks to, I'm not sure if I understand. I'm sorry, I'm not sure I understand the question. The mom would decide whether she wanted the cancer treatment, at the risk of the child. That would be the mom's decision, of course.
So in a DNR circumstance, if the patient, the pregnant patient, is likely to become unconscious at some point, can they have a DNR that instructs the physician on which life to save, hers or the fetus?
Senator, that situation is not expressly provided for in the bill or any other Texas abortion laws that I'm familiar with. That's not specifically provided for in this bill. But again,
I agree with you. I just wanted to make sure. I'm also curious about Section 10, the allowance for accepted abortions in certain places. In Section 10, an accepted abortion can occur outside of a hospital circumstance, but only if it is an unlicensed facility that is not also prohibited from receiving state funds.
Senator, that's right. So to walk through the exceptions, what that provision is intended is to say, in a situation where a pregnant mom is experiencing a medical emergency, her life is in jeopardy, and there is not a hospital within a reasonable distance for her to receive care, the medical emergency can be treated elsewhere, but not at an abortion clinic. So this is not for the setting of an abortion clinic, but it does say that if the mom needs help, it does not have to be in a hospital if that's not practical. The mom's life is paramount.
So it can occur at a birthing center, for instance.
That's right. That's what this language is about.
Can it occur at home, in a home birth circumstance?
And that would not be an individual or entity to which funds appropriated by the legislature and General Appropriations Act are prohibited from being distributed. That would not be affected by this. Yes, ma'am, it can.
But it could not occur at a Planned Parenthood facility.
That's correct.
Do you believe this bill will reduce or increase infant deaths?
Obviously, the focus is for this bill is on the life of the mother, but if the moms are getting care, Senator, I don't believe this bill will directly affect infant deaths, and if I'm missing something, please help me.
Only there's concern, understandably, I would think, that between 2021 and 2022, year over year, there was a 13% increase in infant mortality in Texas.
Well, Senator, if broadly, and I think what I'm about to say is logical if we think about the numbers. If more live births are taking place, if there are fewer abortions and therefore more live births, then whatever the rate or whatever was happening with the number of live births we had before, if there are more live births, there'll be more complications, more even infant mortality, because there are more births. Those little babies aren't being aborted. The births are taking place. And so if the number of births goes up, the number of everything else rises with that, if that's what you're talking about. I don't think that's affected by this bill, but please help me if I got that wrong.
Well, I'm asking you whether you think this bill, and it sounds like you do, think that this bill will result in more live births and therefore a higher percentage of those live births with, structural abnormalities and fatal abnormalities in certain circumstances.
Well, Senator, and I was probably imprecise when I talked about the law resulting in more births. I was referring to the heartbeat law in 2021, which led to more births, and of course the overturn of Roe versus Wade, which led to more births. So that was those were the numbers I was talking about. Senate Bill 31, of course, is about life of the mother and protection of the moms in medical emergencies.
Yes, and I recognize I think that we will agree that this bill is neutral with regard to fatal fetal anomalies, rape, and incest. Those are already not an exception under your Senate Bill 8.
That's right. That's correct, Senator.
And so I suppose what you're suggesting is, since they're already not exceptions under your Senate Bill 8, that now your Senate Bill 31 will not increase live birth of fatal structural anomalies, that it was actually your Senate Bill 8 that did that.
Well, if all births increase, then all births will increase. And so across the board, the rate isn't affected, but the raw numbers are. More babies being born. We generally agree that's a good thing, but when the numbers go up, all the numbers go up.
Thank you for answering my questions. I appreciate it.
Thank you, Senator Eckhardt.